Hi guys, welcome back to Simplify. In this video, we are going to cover an interesting topic on Indian Contract Act 2. Let's start with understanding a proposal or offer. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the asset of that other to such act or abstinence, he is said to make a proposal. Essentials of a valid proposal or offer are: an offer is always in the form of a request. An offer must aim to create and be capable of creating legal relationships. The terms of the offer must be definite, unambiguous, and certain. The offer may be specific or general. An offer can be express or implied depending on the circumstances. An offer must be communicated. An offer may be conditional, in which case the conditions must be clearly communicated. An offer is ready to be accepted by the other party. When accepted, it forms a contract. Modes and classification of offer are: by spoken words, in writing, and by conduct. Offers can be classified as general offer, offer made to the public in general and anyone can accept the offer. Special offer, offer made to a definite person and can be accepted only by that person. Counter offer, the offeree gives a new offer after rejection of the original offer. Cross offer, when two parties make offer to each other without knowing each other's offer. Standing or open offer, offer open for acceptance over a period of time. For example, A offers to sell his house to B for INR 25,000. However, B offers to buy the house from A for INR 20,000. Thus, B makes a counter proposal which must be accepted by the original proposer A for the offering to be binding on A. Essential elements or rules on an offer are: offer must create legal relationship. Terms of offer must be definite. Offer must be communicated. Offer must be made with a view to obtaining the assent. Offer must not thrust the burdens of acceptance. Statement of price is not an offer. Offer may be express or implied. Offer may be conditional. And offer may be general or specific. Moving on to acceptance. A proposal is said to be accepted when the person to whom the proposal is given gives his consent thereto to the promiser. On acceptance, a proposal becomes a promise. Promiser is the person making the proposal. Promisee is the person accepting the proposal. For example, A offers to sell his house to B for Rs 50,000. When B accepts this offer made by A, it is termed as acceptance. Essentials of a valid acceptance are: an acceptance must be absolute, that is, unqualified or unconditional. Mode or manner of acceptance can be usual and reasonable mode of acceptance or prescribed mode of acceptance. Acceptance must be communicated to the other party. Silence does not imply acceptance. The acceptance of a proposal implies the acceptance of all terms of the offer. Acceptance must be made by a certain person. The adherence to the conditions of a proposal results in the acceptance of the proposal. The person accepting the offer must be informed about the existence of the offer. The offer lapses if the other party does not accept the offer in a reasonable amount of time. Acceptance must be given before the offer is withdrawn or revoked. Next is invitation to offer, standing offer, or an open offer. A valid offer is not merely a statement of intention. Similarly, a quotation of prices is not an offer but an invitation to a customer making an offer to buy. For example, in the case of specific goods, tenders from suppliers are invited. Each tender submitted constitutes an offer. The party inviting tenders may accept any tender and thus enter a building contract with the supplier. Difference between an offer and invitation to offer is: an offer is just ready to be accepted by the other party. In an invitation to offer, such as advertisements, price lists, window displays and tenders, the person inviting the offer reserves the right to act further before being bound by the offer. The person making the offer does not reserve the right to act further before being bound by an offer. On the contrary, the person making the invitation to offer reserves the right to act further before being bound by the offer. An offer is binding when accepted by the other person or party, while the person inviting the offer reserves the right to accept or decline the offer before being bound by it. For example, A advertises to sell his own house. B, C, and D make offers to purchase the house at different prices. A refuses to accept all offers as it was only an invitation to offer. It is B, C, and D who actually offer, and it is A is to accept the same or not. The last topic in this video is on communication of proposals. Communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. As against the proposer, the proposal is complete when it is put in a course of transmission to him so as to be out of the power of the acceptor. As against the acceptor, the proposal is complete when it comes to the knowledge of the proposer. Communication of a revocation is complete in the following situations. As against the person who makes it, communication regarding the revocation of a proposal is complete when it is put into a course of transmission to the person to whom it is made, so as to be out of the power of the person who makes it. As against the person for whom it is made, communication regarding the revocation of a proposal is complete when it comes to his knowledge. For example, A proposes to sell a house to B at a specific price by means of a letter. The communication of the proposal is complete when B receives the letter. B accepts A's proposal by means of a letter he sends by post. The communication of acceptance is complete as against A when the letter is posted and against B when the letter is received by A. A revokes B's proposal by means of a telegram. The communication of revocation is complete as against A when the telegram is dispatched and as against B when B receives it. A proposal may be revoked at any time before the communication of its acceptance is complete, as against the proposer, but not afterwards. An acceptance may be revoked at any time before the communication of its acceptance is complete, as against the acceptor, but not afterwards. For example, A proposes to sell his house to B by means of a letter sent by post. B sends an acceptance to the proposal by means of a letter sent by post. A can revoke his proposal any time before or when B posts his letter of acceptance, but not afterwards. A proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. Lapse of an offer. Notice of revocation. Lapse of time. Failure to fulfill condition precedent. Death or insanity of prosperer. Counter offer. Rejection and change of law. Let's start with understanding consideration. According to section 2d, when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Consideration refers to what a party to an agreement must get in return for promising to do something. For example, if A agrees to sell his car to B for rupees 1 lakh, the car is the consideration for B and the money paid by B is the consideration for A. Essential requirements of a consideration are: consideration must move at the desire of the promiser. It must move from the promisee or any other person. For example, A gifted a certain property to her daughter on condition that the latter must pay an annuity to A's brother B. However, because the daughter failed to keep her promise, A's brother has the right to sue the daughter and claim the annuity. The words in section 2d, the promisee or any other person, indicate that a stranger to a consideration may maintain a suit. Consideration may be an act of doing or refraining from doing something, or it may be an act of forbearance or abstinence. Consideration need not be adequate. Suit by a third party or stranger. A stranger to a consideration cannot sue in English law, but he can under Indian law. A stranger to a contract cannot sue English as well as Indian law. Exceptions to the rule that a stranger to a contract cannot sue are a beneficiary under a trust, an assignee, marriage settlement, partition, or other family settlements, contracts entered through an agent, acknowledgement or estoppel, charge on immovable property, assignment of a contract, and third-party risk insurance. According to Section 25, an agreement without consideration is void. No consideration, no contract. The following are the exceptions to this rule. Exception 1. An agreement made on account of love and affection. For example, A promises to give rupees 15,000 to his son B on the grounds of natural love and affection. A drafts this promise to be in writing and registers it. This is a valid contract. Exception 2. Promise to compensate for past voluntary services. For example, A finds B's lost purse and returns it to him. B promises to pay A rupees 100. This is a valid contract. Exception 3. Promise to pay a time-barred debt. For example, A owes B rupees 10,000. However, the debt is barred by the Limitation Act. Therefore, A signs a written promise to pay B rupees 5,000 on account of the outstanding debt. This is a valid contract. Exception 4. No consideration is necessary for the creation of an agency. Exception 5. A gift does not require consideration. Exception 6. A promise, though gratuitous, would be enforceable if on the faith of the promise the promisee suffers loss. Other void agreements. Section 26. Agreement in restraint of marriage is void. Section 27. Agreement in restraint of trade is void. Section 28. Agreement in restraint of legal proceedings is void. Section 29. Agreements the meaning of which is not certain or capable of being or made certain are void.